well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Welcome to another edition of Bearing Arms, Cam and Company. My name is Cam Edwards. Glad you're with me on the program today. We're going to be talking with Chuck Michel, head of the California Rifle and Pistol Association, co-founder of the Second Amendment Law Center, about Friday's decision in Rahimi. I think many of us might agree that Zaki Rahimi should not have been allowed to possess a firearm. The question is, how did the court reach its decision, and what does it mean for our right to keep and bear arms going forward? We'll also be talking with Chuck about the lack of orders coming from the Supreme Court in last week's conference. The orders from conference released today. And they turned away one case related to a bump stock ban, where the government was appealing a decision from the Sixth Circuit Court of Appeals that found the ATF rule had overstepped the agency's authority. They granted, vacated, and remanded another case dealing with bump stocks back down to the D.C. Circuit Court of Appeals, a case in which the appellate court had ruled in favor of the ATF's rule. But other than that, I mean, they still left a half dozen prohibited persons cases on the table. Cases like Garland versus Range, U.S. versus Daniels, dealing with nonviolent offenders who were prohibited from possessing a firearm. In Mr. Range's case, because he pleaded guilty to a misdemeanor charge of falsifying his income on a food stamp application like 20-something years ago. He got probation for that crime, but it was a crime punishable under Pennsylvania law at the time by more than a year in jail. So even though Brian Range got probation, he also lost his ability to possess a firearm forevermore. In the case of U.S. versus Daniels, Patrick Darnell Daniels was pulled over in a car. There were firearms. There were joint roaches, I guess. He admitted to police that he smoked marijuana or used marijuana regularly. Was convicted of being an unlawful user of drugs in possession of a firearm, sentenced to 46 months in federal prison for possessing guns while using marijuana. That case, again, has been pending along with Range and 4 other prohibited persons cases for a couple of months now. And the expectation was that after Rahimi was decided, these cases would most likely be GVR'd. Granted, cert, vacate the lower court decision, send them back down to the lower courts for a redo in light of Rahimi. If that's going to happen, it's going to be next Monday, because that's really the last time. I should say if it's going to happen next Monday is the last time before the fall that the court will have an opportunity to weigh in. You still also have the Illinois gun ban cases, excuse me, and you've got Antoniuk versus Hochul, which is a challenge to one of the post-Bruin carry provisions in New York State, the reliance on a good moral character standard before issuing a concealed carry license. The court said in Rahimi last week that telling somebody that they don't possess their Second Amendment rights because they're, quote, irresponsible, that's not fitting with the tradition of gun ownership in this country. So I kind of anticipated that we would see something on Antoniuk versus Hochul, even if it was just remanding that case back down to the Second Circuit for a do-over. Maybe that comes next week, but it did not come today. So again, we've got a lot to discuss with Chuck Michel. Before we get to that conversation, let's talk about this for just 1 second. Economists warn that massive tax hikes could devastate your IRA and 401k account as the stock market braces for impact. With inflation on the rise and global uncertainty looming, it is clear why central banks and savvy Americans are turning to gold. If you have not had your eye on gold, well, it's time to make it a priority. Priority Gold. Trust their team of proven professionals to help you diversify your savings with gold and silver. Call 1-800-405-GOLD or visit PriorityGold.com/golden for a free gold info guide. Plus, see if you qualify for free shipping and storage. Experts agree that physical gold is one of the best ways to fortify your savings, no matter the economic climate. Act now to get your portfolio working for you while the market's golden. Call 1-800-405-GOLD to speak with a gold specialist or visit PriorityGold.com/golden to learn more. That's 1-800-405-GOLD. And now let's talk with the man himself, Chuck Michel, head of the California Rifle and Pistol Association, get his thoughts on Rahimi, the good, the bad, the ugly, as well as the confounding moves, or the lack thereof, from the Supreme Court in conference. Take a look and a listen. Chuck, thanks so much for coming on the program. It is good to see you, sir.
Always a pleasure, Cam. Thanks for having me.
Yeah, you bet. All right, so I do want to talk about what the Supreme Court did and did not do today in its orders from conference, but I think we probably need to talk about Rahimi first. To kind of set up where we are here with the some of these outstanding cases. So Yesterday or last Friday, Chuck, 8-1 decision. Supreme Court says Zaki Rahimi can be barred from possessing a firearm under a domestic violence restraining order. What did the court do here in Rahimi? How did the court reach its decision?
Well, in a nutshell, it said there is a historical tradition of disarming dangerous individuals, at least temporarily. So that historical tradition justifies disarming Mr. Rahimi, who had been found to be, after a hearing, he got his due process, after found to be a dangerous individual and was temporarily, based on a restraining order against him, prohibited from possessing firearms. So there's some significant limitations on that. First, remember the Bruin test. Text, which they've played a lot of games with. Some courts have played a lot of games with, tried to say that does the right to keep and bear arms, what's an arm, who are the people, is a magazine an arm? They're saying no. Is a semi-automatic an arm? Which, by the way, brings in the Cargill decision that we also got last week.
Yep.
On bump stocks. But so the first question, it's not a test, it's a question, is whatever it's being challenged, the conduct or the arm, the hardware, covered by the text of the Second Amendment? The answer to that question should almost always be yes. Then the second question is there a historical tradition of regulating the type of conduct or arm or class of arm that is being regulated by the modern law? So the determining whether there is a historical tradition is typically done by looking to analog laws from either 1791 or at the after the passage of the 14th Amendment. And there's debate about that too, whether it should even go to the Reconstruction era or just be when the Bill of Rights was signed. But what laws existed that would indicate that the founders would tolerate, in their minds, that the Second Amendment would tolerate the modern law? So what the Rahimi court did was say there were a couple of laws, surety laws, which basically was like you had to get a character reference and insurance if you were deemed to be risky. And so if you did anything stupid, you would lose your money and be, punished. And then there were some affray laws, which basically meant you can't go around terrorizing the country, which I don't know exactly what that meant, but they found that those two things, which could be used to disarm dangerous individuals historically, were enough to establish a historical modern day tradition. Now, Justice Thomas was the lone dissenter in this 8-1 decision and said that's not that's not a close enough analog to justify disarming someone who hasn't been charged with a crime. It's just a restraining order. So how is that going to play out in the courts is the question.
Yeah.
Does that loosen up the connection that's going to be required between a historical law and a modern day law for a modern day law to be upheld? Well, I know damn well that the Everytown law lawyers, Bloomberg's lawyers, are drafting their arguments to that effect now.
Mm-hmm.
They're getting ready to play this. But the more I look at this, and it's a long decision with multiple concurring and dissenting I should say, opinions, the less concerned I am, because there is simply there's nothing in the past that would justify banning an entire class of modern firearms that are commonly possessed, like semi-autos. There's nothing that in no historical law that would indicate that you can ban a CCW license holder from possessing in almost every public place, which is what the deep blue states that Bloomberg has in his pocket are trying to do. So I don't think that it's going to get the traction that I'm sure the attorney generals in various Illinois, California, New York, New Jersey, Maryland, or Massachusetts are hoping for. But the bottom line, I think, really is that if a court was going to uphold a gun control law before, and many in the Ninth Circuit, judge, I should say, not court, if a judge was inclined to find some flimsy analog law to justify a modern law, and many of them were, especially in those battleground circuits, they were going to do it then, they're still going to do it now. So it all depends really on, and one good thing that the courts said in Rahimi is that, this jurisprudence, this area of law is under development. And so they recognize that they need to take more cases and clarify some things. And that brings us to what didn't happen today, which was they did not take any of the cases, but they didn't deny, they did not turn down the cert requests on these cases either. So there was some Illinois cases and the Antonic case from New York and the Range case about prohibited people. So none of those have been taken up or shot down yet.
Were you surprised that the orders from conference came out and we didn't see any action on those cases today?
Well, frankly, one theory was that they were waiting to, those cases, those conference cases have been postponed, I think, 4 times now.
Yeah. The prohibited persons case is even longer. I mean, they've been hanging out for a couple of months. Yeah.
Yeah. So one theory about why the court was postponing the decision on whether or not to grant cert was that they were going to see what happened. They were going to wait, publish Rahimi, and then maybe GVR, grant, vacate, and remand. In other words, they were going to take those cases, but not get them into the normal Supreme Court cycle of briefing and oral argument, and just say, look what we just said in Rahimi, you're wrong, reconsider it in light of what we had said in Rahimi. That's the GVR, grant, vacate, and remand. But they didn't say enough in Rahimi, in my opinion. They did not change the law. They reiterated what the law of Heller and Bruin was, but they didn't change it. The only thing they really did different was, in Justice Thomas's view anyway, not be strict enough in determining what kind of historical analog law might justify a modern law. So that's not enough for GVR, I don't think. So that means, why are they waiting? Well, the classic reasons they could be waiting are there's a denial with a dissent, and they're giving the dissenting judge time to write his dissent, or they're going to grant cert, or they're simply going to deny cert. It's possible they could do a per curiam opinion, basically, or just a form of GVR, say you're wrong. But now we're really reading tea leaves. The positive sign is that the Supreme Court justices, in their concurring opinions, recognize that they really need to take more cases. So maybe one or more of these will be the cases they take.
I wrote a piece over the weekend kind of previewing orders from conference, and I'm glad that I included the possibility that the court would take no action at all today. I called it the most frustrating option. And it is, it is frustrating. But I also said that I am slightly less pessimistic that the court is simply going to deny cert after seeing Rahimi, because like you, there is not a lot there that would implicate the Illinois cases. But you did bring up Cargill, which does obliquely play, I think, have an impact on the Illinois cases, right? Because the Supreme Court said in Cargill that if you attach a semi-automatic, if you attach a bump stock to a semi-automatic firearm, you do not turn that firearm into a machine gun. The Seventh Circuit has ruled in these Illinois gun ban cases that semi-automatic firearms, semi-automatic rifles anyway, by themselves, without a bump stock attached, are like machine guns. And to me, Cargill is clearly in conflict with what the Seventh Circuit held about bans on average, normal, modern sporting rifles.
Right. Cargill made it clear that a semi-automatic is not a fully automatic. Surprising that it took 9 fairly smart people to make that distinction, which every freaking guy who owns a gun knows. I mean, one trigger pull is semi-automatic, hold the trigger down and it keeps firing. That's fully automatic. I mean, it's pretty basic stuff. And it kind of indicates how, they want to draw, this is Bloomberg's lawyers' gambit. They want to blur the line between semi-automatic and fully automatic. They want to talk about firing, rate of fire, try and pretend there's no difference. You can pull the trigger fast enough to mimic a machine gun, which is not true. So there's no difference. And so you can ban semi-autos just like you can ban full autos because they're basically the same. And the Cargill decision, in a sense, it's a fine line because when you get into bump stocks, the question was, what does that bump stock do? And what it does is it makes your finger go back and forth faster, but you still have to pull the trigger with your finger that is accelerated by the bump stock every time you want a round to come out of the barrel. So that's been clarified right down to diagrams, which I loved seeing the anti-gun groups go nuts over. Judge Thomas, including some of the diagrams from some of the amicus briefs that were submitted. But we Second Amendment Law Center, CRPA, the Second Amendment Defense and Education Coalition out of Illinois, FFL Illinois, the FFL group there, we all submitted an amicus brief in Cargill warning the court that this was the gambit that the Bloomberg lawyers were trying to play. And make no mistake, the Bloomberg lawyers are running this show. They're running it in California. They're running it in Illinois. They're running it in New York. I mean, they're, ghostwriting half the stuff that's being submitted by the state attorneys general.
Don't forget the White House, too. I mean, you've got Rob Wilcox, formerly of Everytown Law, and in fact, we were talking last week with Pete Friselli, who's one of the whistleblowers in Fast and Furious, retired Deputy Assistant ATF Director. And he said that he's been hearing that the White House Office of Gun Violence Prevention tried to get the ATF to implement a rule that would have reclassified Glocks as machine guns because of their, supposed readily convertibility, right? And according to Friselli, Steve Dettelbach refused to go down that road, at least for now. But you're right. I mean, this is the gambit, right? To conflate and to equivocate semi-automatic firearms with machine guns. And if you can ban machine guns, well, then you got to be able to ban these semi-autos as well. All right, so you think that Cargill might actually have an impact then on these Illinois cases that are still pending before the court?
Well, I can tell you this. Okay, so the Illinois appeal is in the Supreme Court right now. The Illinois trial court, the Illinois Court of Appeals basically did not definitively decide whether or not the law was constitutional or not. It said, you're not likely to succeed on the merits, so we're remanding it back down to the trial court for further fact-finding. And that's what's going on in the trial court right now in Illinois. The district court is going to have a trial, probably in September, on where we've been working to put together expert testimony on all the things that the state is claiming about semi-autos, whether they're in common use, what their rate of fire is compared to full auto, what their civilian uses are versus military uses. All of this, we probably got a dozen experts that are going to submit declarations and or testify in Illinois about how wrong the Seventh Circuit was on their factual conclusions. And so I think we have a very good chance of prevailing again in the district court, and it may go back up to the Seventh Circuit, which, by the way, is one reason why the Supreme Court might not take the Illinois cases at this stage, because it's an interlocutory appeal from the denial of a preliminary injunction, not a final judgment. Remember, typically when we go to court on these civil rights cases, you file your complaint, your lawsuit, you seek a preliminary injunction that's either granted or denied. And typically that preliminary injunction gets appealed. But if it wasn't appealed, or even if it is appealed, you can continue in the trial court through discovery and expert testimony and all that stuff. You put your case together, you get the information from the other side, you go towards a judgment and permanent injunction. And that's where we're at. We're in that second phase in the trial court in Illinois right now, and in some other cases too. But most of the cases that are up on appeal are on appeal from either the grant or denial of a preliminary injunction. Now, the Duncan case, Judge Benitez was smart enough to convert all those things to judgments, to final judgments. So they are not interlocutory. Those cases, Duncan had its en banc argument. We're waiting for that opinion, and a number of other cases are backed up. Duncan is the magazine capacity limitation law in California that would take your magazines away from you. And then there's Rhodey, the ammunition background check law, and ban on internet sales. There's two assault weapon cases, Miller and Rupp, so-called assault weapon cases. And there's several other cases that we're back in this bottleneck again that we were several years ago, waiting to see what the en banc panel is going to do on Duncan.
Okay. I want to go back to the Bruin test, if we can, for a second. There's been a lot of talk, about maybe Amy Coney Barrett's breaking with the originalist wing of the court. She clearly didn't have a clean break in Rahimi. She talked about the importance of history, right? But Chuck, one of the things that I'm concerned about, I'm not an attorney, obviously, but I am an armchair historian. And so, I've been doing a lot of reading about the Reconstruction era as of late. And one of the things that really strikes me is that if the tradition of firearms ownership is only going to be related to the laws that were put on the books, I don't know that actually tells the story of our tradition of keeping and bearing arms in this country. Go back to the... Go ahead. I'm sorry.
Go ahead. No. You go back to what? Go ahead.
Well, I was going to say, you go back to the Deep South right after the end of the Civil War, and you had, not only the formation of these, like the Union League, right, which was basically freedmen who would get together. They were advocating for their freedom, but a lot of these individuals had, old busted shotguns. They would stand guard over the Union League meetings. There was the formation of these not official militias, but basically armed citizen groups, right? Who were protecting the community.
The tradition was that every man be armed.
Exactly, right. So they were extras. That was their view of the right to keep and bear arms. That we want to be a part of that tradition. But at the same time, you had the black codes that were implemented right after the aftermath of the Civil War. When those were struck down, you had these, statutes that were maybe facially, racially neutral, but applied in practice. Again, the intent was to disarm these freedmen, to prevent them from keeping and acquiring the type of modern firearms, right? The breech-loading rifles, the things of that nature. They didn't want the freedmen to own those. If they had their old, single-barrel shotgun, okay, maybe we're not going to go door to door and take them away. But that, to me, is also a part of this story. And if you just look at the statute, you're missing so much of the real tradition and how it was exercised, and the men and women who fought for those rights. So help me out. What does the court consider? What does the court look at when it's looking at the tradition of gun ownership in this country?
That is a very good question. And it's actually something that, and I haven't finished reading the 100+ pages of Rahimi yet and all the concurring opinions. But that's a question that I've been asking myself. Is the tradition, it's more than just what laws were on the books. Now, the double-edged sword of this is, there could be policies and that were like disarming the freedmen and not letting guns into town and stuff like this that could be used to say that the tradition was always to restrict things. But the true tradition was everybody was, in 1791, everyone was expected to own a firearm and expected to be ready to use it to defend liberty or for anything else. Hunting, self-defense, whatever activities there were that the colonists engaged in. That was the tradition, and that tradition didn't change. That tradition carried over, into the 19th and 20th centuries. it's changed more recently because of some of the laws that were passed. But the ultimate tradition was great respect and very few limitations on the right to keep and bear arms. Now, I don't know how that's going to play out in court if they're going to go beyond. The problem is you go beyond the historical analog statutes and you get into junk history. There's historians who will say anything you pay them to say. So, academically, I'm thinking along the same lines. I'm trying to read through all this stuff and figure that out myself.
All right. Well, if you want, I've got some books I can ship you and let you do a little bit deep dive. So,
well, I'm going into Steve Hallbrook's. A lot of Steve Hallbrook stuff is very helpful on this. So, but yeah.
Yeah, I just picked up a book a couple of weeks ago about the Negro militias during Reconstruction that was written, I think, in the 1950s. And, I mean, there's all sorts of these interesting nuggets. And I think that, to me, it comes back to, when you talk about these attempts to, let's say, restrict freedmen or restrict Native Americans or Catholics, if you want to say that that's a part of the tradition, my argument against that would be, no, that might be part of a tradition of gun control. But all of these groups were fighting to possess the same rights that the majority, that the people, as defined by the law at that time, which was, predominantly white men. They were fighting for the same rights as those white men, those landowning white men in the South, that they already possessed, right? And that's been the conflict throughout this nation's history: is who is the people? And what are those rights that they're entitled to? And to me, when you look at the Second Amendment, it has been that fight for equality. Well, I want the same right that the Night Riders, that the KKK, that these individuals who are trying to oppress me enjoy. I want my right to be able to defend myself against those folks. And that's what the right to keep your arms is. To me, it's the right of the underdog. The right of the people to keep their arms is the right of the underdog to protect themselves against again, in many cases, the majority of the population in their community or in their state who would inflict violence on them.
Yes. I mean, because that's the rights that traditionally the oppressor typically already had.
Exactly.
And so it's empowerment, and it's a battle over, historically, it's been a battle over our own tyrannical government or doing tyrannical things to disfavored classes. And so, yeah, I mean, you're onto something here. Yeah.
All right. Well, now I just need to go to law school.
I don't know how that's going to play out, but we'll be. I mean, I can see Saul Cornell is going to come up with a bunch of traditional stuff that.
Right. I know. That's
historian, the so-called historian expert who, typically submits something about how they always banned everything everywhere and historically.
Right. Exactly. I know. And again, I'm glad to hear that you say that the more you look at Rahimi, the less bad it seems to you. And again, I don't think there are many people in this country. Holding. Yeah. And I don't think many people in this country would say Zaki Rahimi absolutely should be able to possess a firearm. I think a lot of people agree that Zaki Rahimi's actions.
He's not the poster child for gun rights. He's a dangerous person.
Yeah. But again,
if there might be a silver lining in Rahimi, Mr. Rahimi himself individually, put aside, they talked about the reason they could disarm him because he had due process and it was temporary. He had notice and an opportunity to be heard, and it was a temporary restraining order. It was going to expire. There are policies in place in LA County Sheriff, in Illinois with the FOID cards, where if someone had a restraining order and it expires, and they may or may not have had due process in getting that restraining order against them, they are deemed to be irresponsible. And so they don't get a CCW, or they don't get the FOID, the Firearms Owner Identification Card in Illinois, which means they lose their right to carry a gun with a CCW, or they lose their right under the Illinois law to have a gun at all. And those types of revocations seem to be prohibited by Rahimi. So we're getting ready to litigate that in our case against the LA County Sheriff for they're saying, if you ever had a restraining order, one guy had his guns stolen out of his house, not his fault. And they're saying, well, you're irresponsible, so you can't have a CCW. I mean, that's the kind of thing that Rahimi seems to say the government can't get away with as a policy. So, and then there are restraining orders in California where you don't even get notice of the hearing necessarily. Suddenly you get notice that you've lost your gun rights, and there's a restraining order filed by some disgruntled ex-husband or wife or spouse or girlfriend or boyfriend or whatever, that's looking to gain an advantage in a separation proceeding. Mm-hmm. So there's lots of abuses of the restraining order process, and Rahimi seems to say some of those are you cannot be used to justify revoking your Second Amendment rights.
Yeah, particularly Gorsuch's opinion was, very, very big on pointing out what Rahimi did not say, the questions that were left outstanding. I know that the court is slated to wrap up its release of opinions this week. Generally, they do some sort of, final conference. So I'm anticipating we'll get more orders next Monday. Is that what you're anticipating as well?
Yes. And I think we're going to see some, Thursday and Friday are going to be big ones, not gun ones, but big ones. Chevron deference, this was kind of what Cargill was. It wasn't a Second Amendment case. It was whether or not the ATF as a regulatory agency can change its mind after years of telling people that bump stocks are not machine guns and they are legal and you can have them, change their mind and say, oh, oops, our bad. They actually are, and you're all criminals. I mean, that happens all the time with regulatory agencies, not just ATF. EPA is notorious for this. And so if they rein that in, that's going to be huge. There's a bunch of, and obviously Trump immunity. There's a lot of blockbusters still to come.
There are, and hopefully we'll get some word next Monday. I don't know I don't know if you have any plans next Monday morning, Chuck, but you want to join us again for Cam and Company?
Let's write it in. Same time same bat time, same bat channel next week.
All right, Batman. I appreciate you doing that. Thank you for coming on the program today, and look forward to doing this again a week from today.
Thanks, Cam. Me too.
My thanks once again to Chuck for joining me on the program, and who knows? Might have Chuck back on next Monday when we get what should be the final orders from this term. Before we get to today's Armed Citizen story, our good deed of the day, and our recidivist report, let's talk about this for just 1 second. At the very heart of our democracy lies a principle that we hold sacred: free speech. It's the cornerstone that supports every freedom we cherish. Yet in today's digital age, discussions about our wealth, our rights, and our future are being silenced or overshadowed in mainstream narratives, leaving many feeling voiceless in conversations that are crucial to our financial independence and security. This is where wealth protection research steps in, armed with a mission that's never been more critical. Wealth protection research is not a financial advisory firm. They are defenders of free speech, committed to giving a voice to the silenced. Now, wealth protection research seeks out financial experts, the voices that challenge prevailing narratives, especially as we navigate the uncertainties of the 2024 election. Wealth protection research has created a 2024 election wealth protection report. Now, this free report highlights the 3 best ideas for protecting and growing your money heading into the 2024 election. It contains ideas the mainstream media won't touch, and listeners can get it absolutely free. Just text IDEAS to 76626 to claim your free copy. If you believe in the sanctity of free speech and the importance of financial freedom, then act now. Text IDEAS to 76626 to claim your free copy of this 2024 Election Protection Report. It's time to widen the scope of what we're told, to hear the ideas the establishment doesn't think you can handle, and to take control of our financial destinies. Text IDEAS to 76626 to claim your free copy. All right, now let's turn our attention to today's Armed Citizen story, our good deed of the day, and our recidivist report. We will start there with a case out of Rochester, Minnesota, where police say a convicted felon robbed a motorcyclist, a Rochester business. Apparently the motorcyclist, dismounted, took off his gloves, took off his jacket, and then some guy walks up and takes him. And the guy says, "Hey, give me my jacket back." That's when the suspect reached for his waistband as if he had a gun inside, and then walked away. Suspect actually did one sort of, semi-redeeming thing. And the guy, after he said, give me my jacket, and the guy reached for his waistband, he said, okay, can you at least give me my wallet? Suspect then allegedly threw down the victim's wallet and left the area. Police found the suspect, identified as 23-year-old Eugene K. Anthony Washington Jr., and did find some of the belongings that belonged to the motorcyclist, as well as a hammer in Washington Jr.'s waistband, a knife in the right pocket of a jacket that he was wearing. He also, again, had the items that the motorcyclist had previously reported stolen. KROC in Rochester, Minnesota reports that Washington Jr. was sentenced to 5 years probation back in March of this year for third-degree assault. It is a felony that stemmed from an attack on a fellow patient at St. Mary's Hospital in February of last year. He was also, at the same time, sentenced to 5 years probation for illegal possession of a sawed-off shotgun in a separate case that was opened in May of last year. Now he's been charged with felony counts of aggravated first-degree robbery as well as terroristic threats. Bail set at $100,000 without condition. He is due back in court next month. And based on his previous criminal history, again, 5 years probation just a few months ago for two separate felonies, one of which, by the way, would have been punishable by up to 10 years in prison if this had been prosecuted in federal court. Slap on the wrist and on his merry way. And by the way, lawmakers in Minnesota this year taking aim more at legal gun owners than at convicted felons like Mr. Washington. They are taking a soft approach to dealing with repeat offenders. Today's armed citizen story, and I got to thank Dale for sending me this story from Virginia. Franklin man chases after children with knife. Neighbor jumps into action. Note, by the way, no mention of the fact that the neighbor who jumped into action had a firearm, right? Nope. But that is, in fact, what happened. Franklin, Virginia, this was last Wednesday. Home surveillance cameras catching a man chasing two children while armed with a knife. Terrell Majette was hanging out on his front porch talking with his brother about 6 p.m. last Wednesday when all of a sudden he sees this little girl and boy come running towards him. The little girl told him, there's a man chasing after us with a knife. So he said the boy ran home. The girl ran up onto his porch, terrified. He says, instantly, I ran into the home and I grabbed my firearm and I came out as soon as I stepped on my porch. My brother was telling me from the car, hey, bro, he's charging. He's charging. Terrell Majette calmly told the man, go back to your house. Don't set foot on my property. He said, I went into protection mode, went into father mode. That's the first thing. Majette's wife, Rachel, took the little girl inside. She called 911. Rachel Majette said the little girl was shaken up. She was crying. By the time she got home, I think she was still crying, her grandma said. Channel 10, WAVY, just said that they obtained a doorbell video that clearly shows the man with a knife trying to charge at the children next door, and he then began stabbing at the ground. Terrell Majette said the last thing I wanted to do was to harm him or see him harm any of these kids. He said, I was robbed at gunpoint in 2019 in Atlanta, and it shook me to the core. So I've been dealing with that, being clinically depressed with PTSD. You know, when she came up, all I could think about was, what if it was my child? What would I do? Incident report from Franklin Police shows a man 29 years of age, known to police already, although we don't know why. He was taken to a nearby hospital, apparently for a mental evaluation. Terrell Majette says he couldn't have asked for a better outcome. He says, I'm just glad I was able to maintain my composure and de-escalate the situation. Children unharmed. The suspect, again, in custody, hopefully getting the care and treatment that he needs. And this could have ended very, very differently if it weren't for the fact that Terrell Majette had a firearm and was able to use that firearm, again, without firing a shot, but just the presence of that firearm in his hand enough to stop this from escalating any further and to stop any harm from being done to those kids. So I know that we generally say this with our good deed of the day, but in the right place at the right time, willing and able to do the right thing. Terrell Majette, you deserve a very big tip of the hat for your incredibly good deed. Now, speaking of good deeds, let's talk about what a Connecticut police officer did to save the lives of two kids whose father was allegedly trying to drown them. This was over the weekend. Officer on patrol about 2:30 in the morning and runs across the sounds of screams coming from the water. This was in West Haven, Connecticut. Again, it was about 2:30 Saturday morning. The officer heard the screams, went down to the beach towards the water. He saw a man identified later as 41-year-old Romney Desrenville, 41 years of age. He was there with two kids who were struggling. Officer stepped in the water. Desrenville continued to drift further away with the children, all while screaming and responding at responding officers to, quote, stay back, according to the West Haven Police Department. Statement read, it was obvious at this point that the male was deliberately drowning his children. So other officers, members of the West Shore Fire Department, then rushed to the scene. They waded out nearly 100 yards into the water. Again, Desrenville keeps going deeper and deeper into the ocean. The officer who first responded was able to grab the children, both of whom were younger than 3 years old, and bring them back to shore. They were taken to a local hospital. They were being treated in intensive care. So, unfortunately, the father, in this case, was apparently able to harm his children, even if he was not able to kill them. Charges against Desrenville are pending. Residents in Flushing, Queens, where Desrenville lived, described him as a kind and helpful neighbor, calling him a family guy, a fantastic father to his small children. One man said, everything's always been peaceful. It's completely out of the blue, completely out of character. 19-year-old Miguel Ruiz says he's a nice person. He just seems very sweet and very kind. He doesn't seem like the type to do that. And he said that he hoped his neighbor's arrest was, quote, just confusion on the part of police. He says it's confusing to me because I just can't believe that someone would do that, especially someone like him. He doesn't seem like the type. Unfortunately, when mental breaks happen, people aren't who they normally are. Again, we don't know that that was the case here, but apparently something going on in this individual's life that he would try to kill his two children, or at least to try to harm them. Thankfully, again, because of the quick response of the police officer there in West Haven, Connecticut, the kids were saved. Dad is in custody. A lot of unanswered questions, but hopefully justice will be done here in the future. All right, that is going to do it for this edition of Bearing Arms Cam and Company. I want to thank you for being a part of the program as always. I'm looking forward to being back with you again tomorrow. I don't know what we're going to be kicking around, but I'm sure it'll be informative and hopefully entertaining as well as enlightening. In the meantime, don't forget to check out BearingArms.com throughout the day. We're keeping you up to date on all of the latest Second Amendment news and information from all across the nation and beyond. And if you like what you see, I would encourage you to become a VIP or VIP Gold member. Just use the promo code SAVEAMERICA and you can get 50% off your VIP or VIP Gold membership. You'll get exclusive content, an ad-free experience, the ability to comment on stories, other bennies, but you'll also be supporting the independent pro-Second Amendment journalism that we're doing at Bearing Arms. And given the rampant media bias and the big tech censorship that we are facing, your support is critically important. So thank you again. Have a great rest of your Monday, as good as Mondays can be. We'll see you back here tomorrow for another edition of Bearing Arms Cam and Company. Until then, be well, be safe, and be free.